Well, welcome everyone. My name's John Tasulis. I'm director of the Yo Chong Lei Center for Politics, Philosophy and Law. And this is a very special event. The subject of tonight's panel is the momentous decision taken by United Kingdom voters on the 23rd of June to leave the European Union. And that decision raises many, many questions, but this panel has been asked to focus on two broad questions in particular, which I'll read out. One, what are the requirements, legal and other, that must be satisfied in order to give proper effect to the vote to leave the European Union? And second, to the extent that there is room for maneuver in negotiations, which version of Brexit would secure the best political and economic outcomes for the United Kingdom and for the EU. So our aim is not to reopen the question whether or not it is a good idea for the United Kingdom to exit the European Union, although of course that is a perfectly legitimate question. But one's view on that question may of course influence the answer to the two questions that I've identified. But for present purposes, I think it's important to note that being for leave or remain does not logically dictate any particular answer to those two questions. People who agreed on remain or on leave may disagree in their answers to the two questions I've set out, just as people who disagreed about leave or remain could broadly agree on the best version of Brexit. So our speakers were chosen not because they hold any particular partisan brief on the issue of leave or remain, but for the quality of their minds and the fruitfulness of the perspective they can bring to bear in addressing our two broad questions. So the speakers will speak each for 10 minutes, and that, all going well, should leave 1 hour for discussion. Those of you who are interested in tweeting, we're going to be using the hashtag Brexit YTL. So Brexit YTL. So with those preliminaries out the way, I'm now going to invite as our first speaker, Professor Takis Tridimas, who is Professor of European Law here at the Dickson Poon School of Law. Takis.
Thank you very much. It's a great pleasure to be part of the panel. The exit of any member state from the European Union is a momentous decision with profound legal, political, and economic implications. Given the nature of the EU, and in this case, given the long-standing membership of the United Kingdom, Brexit is more akin, I think, to a form of secession than withdrawal from an international treaty. Withdrawals from international treaties occur, in fact, with surprising frequency. In terms of its legal implications, I do not think it is an exaggeration to say that it is the most important change since the restoration of the monarchy in 1660. It is an event where legal and political issues are inextricably connected, although I will try and stay as much as possible out of the political ones. I would like to say a few words about the implications of the Brexit vote, the withdrawal, the Article 50 process, what I call the withdrawal and re-engagement conundrum, and then the role of the Parliament of the United Kingdom, and finally the interplay between free movement of labour and the internal market. Implications. First, one among the many, I would like to highlight three implications of the Brexit vote, which I hope are uncontroversial. First of all, the Brexit vote has given rise to an enormous amount of uncertainty and resulting inefficiencies. The scale of inefficiencies is in fact daunting. Managing Brexit has become and will continue to be, for the years to come, the main preoccupation of political leadership in the United Kingdom and of the civil service. The transaction costs of public administration, in other words, have increased exponentially, as have the transaction costs for businesses and the uncertainty for individuals. Secondly, irrespective of the motives or objectives of individual voters, it is difficult to avoid the conclusion that the no vote has empowered and legitimized some illiberal causes. It has promoted nationalism, xenophobia, and isolationism, and created political capital for parties, both at home and abroad, which favour a nationalistic agenda. Thirdly, I think the Brexit vote places the United Kingdom in a trajectory of conflict with the European Union. It is a rejection of the integration blueprint. It is a rejection of the aim of pursuing a common EU-wide vision of solidarity and prosperity. And although undoubtedly within the EU, member states negotiate hard and promote their own individual interests, they do so under the umbrella of certain processes and under the subject to commitment to shared overarching principles. Once the UK goes out, then it will be in a competitive relationship with the European Union, both in relation to both vis-à-vis the EU, but also vis-à-vis third states. Now, none of what I mentioned is necessarily a reason to suggest that the Brexit vote was the wrong vote. One may think that none of the above consequences that I outlined are undesirable. One may also think that on a cost-benefit analysis, the adverse consequences that I outlined are a fair price to pay for deriving the sovereignty dividend that results from Brexit. Article 50 it governs the withdrawal of a member state from the EU, and to my mind, its main points are the following. First of all, it is an exclusive procedure. A member state may not claim a right to withdraw from the EU under terms other than those provided for in Article 50, except in exceptional circumstances permitted by the Vienna Convention, which in this case clearly do not arise. So failure to abide by the process of Article 50 would be a breach of both EU and international law. Commentators distinguish three kinds of withdrawal models in federal or quasi-federal systems. Under the state primacy model, a constituent part or a state can withdraw at will. It has an unqualified right to withdraw. Under a federal primacy model, such as it exists in the United States, there is no right of secession. And finally, under a federal control model, there is a qualified right of secession. Article 50 appears to me to be very close to the first model that I outlined. It is a model based on state sovereignty. It does not. It provides for a process, but for no substantive conditions of withdrawal. A member state does not need to give reasons or any justification for withdrawing, nor is decision subject to any system of approval on the part of the remaining states. But apart from that, I think the process of Article 50 is neutral in terms of political power. It favors, in effect, the member states that have more economic and political power. The more power that you have as a withdrawing member state, the more the Article 50 process works to your favor. It seems to me that notification to withdraw, which is the first step in the process, can be revoked. There is a legal debate about this, but it appears to me that a notification to withdraw by a member state is eminently revocable for the following reasons. First of all, notification is the exercise of the sovereign will of a member state. It is a unilateral act, and for that reason, it can be revoked. Secondly, no legitimate expectation arises on the part of the rest of the EU that a member state that gave notification will leave the European Union. Thirdly, the revocability of withdrawal is in line with the Vienna Convention on the law of treaties. And fourthly, it is also in line with the integrationist spirit of the treaties. This, to my mind at least, it does have certain implications, which we can come to perhaps during the debate, but I move on to the withdrawal and re-engagement conundrum, and what I mean by this is the following. After notification is given, there is a 2-year time limit within which a withdrawal agreement must be reached. the 2-year period may be enough for a withdrawal agreement, but it does not appear to me to be enough for an agreement regulating the future relationship between the United Kingdom and the rest of the European Union. The two are different. Article 50 does not authorize the EU to negotiate anything about its future relationship with the UK. And these treaties, trade treaties, tend to take a very long period to conclude. In this occasion, I think it is not going to be an easy task, first because of the negotiations, secondly because it is likely to need to be concluded as a mixed agreement. In other words, whatever arrangements are made for the future relationship between the United Kingdom and the EU will need to be ratified not only by the EU itself, but also by the member states of the EU in accordance with their own constitutional requirements. In many cases, this requires parliamentary approval, not only of the national parliament, but also of regional parliaments. And last time I counted, for the EU to conclude such a mixed agreement, it requires the agreement of no fewer than 36 parliaments. These things take time, which means, in effect, that there could well be a legal hiatus. The UK may be able to conclude a withdrawal agreement, but not a future agreement will be able to come into force upon withdrawal immediately. So the default position would be the position of the World Trade Organization. This also creates, I think, problems. It's not straightforward. And it appears to me, if one reads at least the US press, from the point of view of financial institutions of third countries who are based in the UK and view access to the internal market as a key aspect of their presence here, WTO default position is not going to be any good. I'm aware of time. Two brief points. First of all, does EU law impose any obligations on the withdrawal agreement or indeed on any future agreement that may be concluded between the UK and the EU? Well, I think we need to draw a difference here. Certainly, any future agreement between the United Kingdom and the EU will need to respect the Charter of Fundamental Rights and other constitutional principles of the European Union. So the EU cannot agree to an international agreement that discriminates on grounds of nationality. So whether it would be possible to have differential arrangements for separate citizens, for citizens from separate EU states, I think it is questionable. We need to look at it in detail. Whether the withdrawal agreement itself is subject to any substantive limitations deriving from fundamental rights is a more delicate question. I think it is. These may derive from international law. They may also derive from European Union law. Let us not forget that the EU is the distinct character of the EU vis-à-vis other international agreements is that it creates a system of rights and remedies. And I don't think that people can be deprived of them overnight. Finally, one word about the involvement of the United Kingdom Parliament in the withdrawal process. It is difficult, for me at least, to see how withdrawal can be effected without an act of Parliament. And the reasons are well outlined in yesterday's report by the Constitutional Committee. The most important aspect of these appears to me to be that the executive cannot take away, cannot abrogate fundamental rights from citizens without an act of Parliament. There is a paradox in that a popular referendum may lead us to having less democracy in the form of enhancing the powers of the executive and reducing fundamental rights, a course which, to my mind, ought to be avoided. Thank you very much.
Thank you so much. Thank you. So our next speaker is Professor Richard Ekins from the Faculty of Law at the University of Oxford.
Well, thank you. I'm grateful for the chance to speak to you tonight. I'm from the Faculty of Law, I should say. I certainly don't speak for the Faculty of Law. And I'm not an EU lawyer or a public policy specialist. I'm a UK constitutional lawyer. And I want to briefly address what it might mean to give proper effect to the vote, and then turn to the question of how the political authorities should go about giving it effect. And the operating question I will try to answer is how Parliament and the Executive should cooperate to secure the UK's exit from the EU in a way that restores or revives parliamentary democracy. So what's the meaning of the referendum, the constitutional significance of it? Well, there's been a great deal of commentary on this point, of course, and much of the commentary has simply dismissed the referendum as meaningless. But the smarter move, I think, has been to say the referendum doesn't establish a specific mandate. There are many post-Brexit arrangements that are possible, and the choice amongst them has not been made. And this often forms part of an argument for a second referendum or a new general election before Article 50 is implemented or triggered. Now, for my part, I don't think the vote is quite so empty as all that. The constitutional significance of it is that the British people have decided the United Kingdom should no longer be part of the EU. And I see the Brexit vote as a kind of counter-revolution against the UK's continuing membership of the EU project, a move to attempt to restore national parliamentary democracy. So the vote is a reaction, as I see it, to the constitutional character of the EU project and its main features. What are those features? The integration of the UK and other member states into a partial state, a state that's the creature of treaties, so in which national executives enjoy a relative priority over national parliaments, in which the organs of that partial state, the Commission, Court of Justice, seek further integration. A partial state that lacks a unified people capable of sustaining a Europe-wide democratic politics. And a partial state, the main part of which has adopted a common currency, which is likely going to require further integration of policymaking and fiscal capacity if it's to survive or flourish. And finally, a partial state committed to the free movement of peoples, and one which aims to transcend nationality. So the vote was a vote to depart from that project, to cease to be part of that supranational polity. And at a minimum, it seems to me, the government and Parliament have a constitutional duty to make it the case the UK ceases to be an EU member state by withdrawing from the treaties of the EU. Now, it's true that there are lots of possibilities consistent with this, including one mooted in the invitation for tonight's event, which is membership of the EEA. And that membership would disentangle the UK, as I understand it, from some, maybe even much, EU constitutional law, but certainly not from all. And I doubt, although I'm open to correction, anyone voted to leave the EU in order to join the EEA. It might make perfect sense as a transitional move, but it doesn't seem adequately to answer to the salient concerns. Well, what were those concerns? The most important of them seemed to me to have been constitutional. The most specific was dissatisfaction with the UK's loss of control over who can enter and remain or settle within the UK's borders. Loss of control over membership of the polity, one might say. And this forms a subset of a wider, more general dissatisfaction with loss of control over lawmaking, a concern that animates people with very different views about what laws should be made, of course. More speculatively, the referendum seems to reveal a disconnect between the interests, the enthusiasms of the elite and that of many voters, and confirms a crisis of political representation, crisis of political trust. So between a stagnant domestic politics and a distant EU membership, we do risk living in a hollowed out democracy. Now, if any of this is halfway right, the referendum reveals a pretty serious problem in our governing arrangements. And political authorities should answer it by doing their best to restore parliamentary democracy, taking the vote seriously, starting to rebuild popular trust by delivering on the concerns about border control and lawmaking. Now, of course, they should also try to minimise the economic impact of Brexit, or maximise the opportunity it presents, if you like, but that seems to me to be a secondary criterion, although obviously a very important one, not an overwhelming controlling objective. Well, let me turn to how to give effect to the vote, the constitutional requirements thereof. Of course, Article 50 outlines a process, but a sketchy one. I think that's because it was designed never to be used. Initiation of it requires notification of the UK's decision to the European Council, and that notice is for the government to give or not give by exercise of the royal prerogative to conduct foreign policy. Now, for some commentators, the use of the prerogative in this way to initiate Brexit is undemocratic, it's perverse even, but there's nothing wrong with the prerogative power as such, provided its exercise is by persons accountable to Parliament. And there's no way to depart from treaties apart from executive action in some way. Of course, the irony here is that the restoration of parliamentary democracy might require extensive executive action, but that seems to me to be the flip side of our long membership, of a treaty-based institution. Now, none of that is to say Parliament doesn't have a role to play in the Brexit process. Far from it. But its role may well vary in relation to triggering Article 50, overseeing negotiations, ratifying the eventual outcome of those negotiations, and making legal provision for disentangling UK and EU law. Now, as I'm sure everyone in the room knows, the government's authority to trigger Article 50 is the subject now to legal challenge. An argument will be heard in October and shortly thereafter in the Supreme Court on Appeal to the effect that the government has no legal authority to trigger Article 50 without an express empowering Act of Parliament. And that argument is clever, it's well framed, it's framed as a vindication of Parliament against the executive. In other words, the argument presents itself as preventing the executive from unilaterally undermining statute and changing domestic law by proclamation. Now, I don't think the argument is sound, and I don't think it should be accepted, and tentatively, I don't think it will be accepted by the courts. The exercise of treaty rights under Article 50, like the conduct of foreign policy in general, isn't prohibited or limited by UK statute, and doesn't involve setting aside statute. The European Communities Act 1972 does not itself commit the UK to the treaties. It applies to the treaties as they are from time to time, and if they're brought to an end, the terms of the European Communities Act have nothing on which to bite. Now, if the court gets this wrong, as I see it, which is possible, then Parliament should promptly enact empowering legislation. But set aside the law for a moment. It might be that the government is constitutionally obliged in any case to obtain parliamentary consent before it triggers Article 50. And in this respect, it's relevant to note that Parliament enacted, by fairly overwhelming majorities, as I recall, the European Union Referendum Act 2015. So it's not in a position to be taken by surprise by the government delivering on the undertaking it made to implement the result of the vote. To my mind, it would have been constitutionally proper for Her Majesty's government to initiate Article 50 the day after the referendum. Wouldn't have been prudent, I expect, and I'm open to correction, but prudence and constitutional propriety are not the same thing. Is there a convention that parliamentary consent must be obtained in a case like this? Well, we haven't really got cases like this before, so there's no convention to hand. My colleague Alison Young argues that there is a convention by analogy with the emerging convention about concerning parliamentary consent to the deployment of the armed forces. And the Constitution Committee, in its valuable report yesterday, drew on a similar analogy, although not quite as strongly, I think. To my mind, the analogy is stretched, and it overlooks the fairly significant distinguishing factor of a national referendum being held on this question. Now, the constitutional case for parliamentary involvement seems to me to be much stronger if it goes to timing and process, so when Article 50 is triggered and what follows thereafter, rather than to the question of whether it should be used at all. And if those 2 points could be disentangled, as the committee recommends, then I think that would be all to the good. But I'm not so sure they can easily be disentangled. The government's position would be more secure, it'd be less fragile, if it was supported in advance, in principle, by Parliament. And at a minimum, the plans that the government, in broad brush at least, intends to act on, the timetable it intends to follow, should be debated in Parliament. The government is accountable to Parliament for the exercise of the prerogative. So the government needs to announce its intentions at some level of generality and give the Commons the chance to choose a different government if it so wishes. I know the Queen technically chooses the government, you get the point. Parliament can't, it shouldn't, and I imagine it won't try to micromanage the negotiations. But it does have to try to hold the government to certain principles, and it has to make sure that no one, itself or the government, undoes or flouts the vote. And it should monitor and have input into the detail of many aspects of the negotiation. And in due course, Parliament will have to decide whether to ratify the post-Brexit treaty terms, as is the case with other significant treaties. Now, I think at each stage, the Parliament should insist that any agreement that's reached doesn't impugn the UK's authority to determine who enters, who remains, or the UK Parliament's lawmaking authority. Parliament should also insist, I think, that any agreement respects the position of settled law-abiding EU citizens, their right to remain. Although there's a difficult question to be answered about the extent to which that protection should apply to persons who enter after the 23rd of June, but before Brexit. Well, disentangling EU law from UK law is obviously going to require legislation, and that's Parliament's responsibility. As far as I can tell, from my perspective, there's no need to change the law overnight. The constitutional concern is freedom to change the law later. And the European Communities Act should be amended to ensure and to maintain continuity. When it makes provision for legal change consequent on Brexit, Parliament will need, I think, to resist the temptation to enact so-called Henry VIII powers, which empower the executive simply to amend statute or EU law in general by fiat. Having said this, it's going to be important to distinguish amongst types of EU law in making provision for change. Some propositions of EU law should only be cancellable or modifiable by primary legislation. Others will be appropriate for executive action. In short, and this is where I'll finish, Parliament has a major responsibility here to support and scrutinise the government in its negotiations with the EU, to hold the government to certain key principles, and to make legislative provision for eventual exit. If it can do this, and that is a big job, it will be doing its part to give proper effect to the vote.
Thanks, Richard. So our third speaker is Lord Norton, who in fact was one of the authors of the Constitutional Committee report on triggering Article 50 that was published yesterday by the House of Lords.
Right, thank you very much. Well, I'm going to pick up where both speakers, particularly the last one, have left off, and both have referred to the report of the House of Lords Constitution Committee that was published yesterday, the invoking of Article 50. I don't want to cast aspersions on what's clearly a very intelligent audience, but I'm going to presume that not everybody in the audience has actually read it. So therefore I will make various references to what the points we make in it. I want to start with a few more overarching observations about the role of Parliament. My starting point is that Parliament has legislated. It legislated for a referendum. And what we did was made statutory provision for a referendum to be held. There was no imposition of thresholds or any particular criteria to be met for the purpose of one side to be deemed to have won. So when the bill was going through, there was really no discussion of whether there should be thresholds or any similar requirements, two-thirds majority or a certain turnout. As far as I'm aware, when the bill was going through the Lords, only one member raised the issue of thresholds, and that was me. And nobody else, certainly not government, took it up. By that stage, the two sides were merely interested in discussing the merits of whether we should leave or remain, rather than the process by which the referendum was to be held. But we've had a referendum. You can't then apply, in my view, you can't apply rules retrospectively. So we've had it, there's been an outcome. So although the point is sometimes made that it's not legally binding, the outcome from a government point of view is politically binding, because the government had a manifesto commitment not only to hold a referendum, but to abide by the result, whatever it was. So the starting point must be that government is committed to it, and it's proceeding on that basis. So really, I think there are three assumptions on the basis of which I'm proceeding. First of all, it's an issue of not if, but how and when. Now, the second point, which we discuss in our report, relates to what you've heard earlier. Now, you've heard that there is a view that once Article 50 of the Treaty on European Union is triggered, then it's still open to the member state who gives notice they wish to withdraw, can unilaterally withdraw that, again, revoke the application that's been made. There's nothing in Article 50 that says you can't withdraw the application, but then there's nothing in Article 50 that says you can. So our view was it's prudent to proceed on the basis that once Article 50 is invoked, we're setting off on a path that we will not be reversing. Now that does have implications, whether to be say, a second referendum, because it would not necessarily be on the issue of terms negotiated versus staying in, but a referendum on the terms. And the third assumption is the negotiations will have been completed, because we have the 2-year period. Negotiations will have been completed by the time of the next general election. People keep saying, well, we might have an early general election. There are two problems with that. First of all, the Prime Minister's ruled it out. Her view is that we need a period of stability. We don't want to be holding general elections. And secondly, which a lot of commentators seem completely unaware of, we have the Fixed Term Parliaments Act. Some commentators are aware of it and say, oh, it can be fixed, which suggests they know the Act exists, but completely have no idea of its provisions. So it's actually not that easy. Yes, it can be fixed, but it's actually quite a difficult process. It is not in the gift of the Prime Minister to call an early general election. She can invite the House of Commons to provide for an early election under one of the provisions of Section 2 of the Act, but it's no longer possible for the Prime Minister to go to the palace and say, please, may I have an election? The Crown's prerogative power in respect of dissolution is completely gone. So I'm proceeding, this isn't in our committee report, it's just my point, that proceeding on the basis that it will be finished by the time of the next election, so you can't hope that there'll be an election and we can refight the battle. Now, in terms of our report, looking at Parliament and Brexit, I think there are essentially three stages that are involved. You've got the initial invoking of Article 50, so the start of the process, and I'll come on to what's Parliament's role in relation to that, building on what's already been said. The second stage is negotiating withdrawal, and then separately, as we've heard, on future relations. And the third is then giving effect in UK law to withdrawal, which can, in terms of amending or repealing the 1972 Act. Some people seem to think if you keep the 1972 European Communities Act in place, somehow this will keep us in the European Union. There's actually a petition to that effect, asking Parliament not to repeal the European Communities Act. I say apparently thinking that will keep us in the EU. It won't. The Act could remain on the statute book after we've actually withdrawn, but we will need to take steps to provide in domestic law the necessary consequences of withdrawal. Now, each of those three stages has different implications for Parliament. Now, in the first one, there is the issue of whether it's actually a requirement or whether the government can trigger it as a prerogative power. As we've heard, that's going to be before the court, scheduled, I think, for October the 13th. I'm already on record as recognising, along, I think, with most others, that it's a prerogative power, which is the government's view. But I would distinguish between consent and approval. So I don't think Parliament's consent is required, it's prerogative power, but that's different from saying that Parliament ought to approve what the government is doing. So, and that's what our report focuses upon, because we think it would be inappropriate for government not to seek parliamentary approval. Not approval for Brexit, but for approval for what it's going to do in negotiations. So Parliament could provide by motion or by legislation the conditions in which government should proceed. There's a strong political argument for it, but there are others as well, because there's a strong case, in our view, for gaining parliamentary support. Some people think, well, if you're seeking parliamentary approval and having legislation will constrain government, the contrary view is actually it will strengthen the position of government, because it would put it beyond doubt that we've satisfied our national constitutional arrangements for withdrawal, and it would provide a statutory base, so you'd have that legally binding aspect. So in the report we do rehearse the merits of proceeding by way of statute or by proceeding by way of motion. Now, as I say, if we do it by legislation, we put the issue beyond doubt, provides legal certainty. The problem is that getting an act through can be a potentially lengthy process, and of course a bill would be amendable and would have to go through both houses. An alternative would be to do it by motion. I've drawn attention in debate before to what happened with the European Communities Act and the bill going through and what preceded it, with government seeking support of the House of Commons by way of a motion. So the October 1971 vote provides, I think, some basis. Now, a motion would be declaratory, but it would be fairly succinct, and it would have the advantage from a time point of view of being quick to get through, and if necessary it could be confined to the House of Commons, and the point's already been made that it would be pretty similar to the view now taken on requiring the Commons to give approval for any commitment of British troops abroad. So it's still a prerogative power, but nonetheless the government still seeks approval of the House of Commons. If you did it on that basis, you could also confine it to the House of Commons. And Conservative MPs, by virtue of manifesto commitment, would be expected to be in support. Either way, our view is, because we're fairly neutral on whether it should be legislation or by motion, nonetheless, should be one or the other, which would provide the government with the support it needs. So that's our view on invoking Article 50. There's then the question, which we're wrestling with at the moment, what's Parliament's role then beyond that once negotiations get underway? And I think the government's got, well, it's not schizophrenic on the issue, but obviously it takes the view that negotiations, it's indicated negotiations, not something it's going to engage in public debate about. Negotiations are going to be private. At the same time, it recognises that Parliament should have some role in the process. Ministers at the moment are rushing around, approaching parliamentarians, committees, seeing what their views are, wanting to get their input. So, and Parliament itself, I think, will wish to monitor, to scrutinise, to be engaged with government as the negotiations proceed. And certainly the House of Lords European Union Committee has already published a report indicating how it intends to proceed and be involved in the process. And we have the benefit of that committee, because it presently works through 6 subcommittees, each with 10 to 12 members of the Lords who are fairly informed on that particular, or the sectors covered by each subcommittee. So we've already got approximately 70 members of the House of Lords engaged on regular, more or less weekly scrutiny of proposals for EU law. So we have a sort of strong base for scrutinising what government is doing once negotiations are getting underway. So that's under discussion at the moment. We recognise the importance of it. We need to get some clear view of what Parliament's role should be. And the final point, the third stage, giving effect in EU law to the necessary steps for withdrawal. In a way, from Parliament's point of view, that's the heavy lifting. You can't avoid using Parliament to enact legislation. It's likely to be a substantial process, because there'll be so much that we need to identify of EU law that we wish to retain or wish to remove. So I suspect what we'll do is initially pass an act to keep the 72 Act in place until such time as we've virtually identified what needs to go and how we need to do that, how much of it will be by primary legislation, whether there's a lot that could be removed through secondary legislation. That's still to be decided, but that will be a massive exercise for Parliament. So that's where we are at the moment. It's fairly broad, it's an overview, but because we've not been in this situation before, we're having to catch up very quickly to decide what is the appropriate relationship with government, what is appropriate, what's not appropriate, then what are the actual mechanisms that we can put in place to deliver on that. But we really are at the early stages, but we recognise we've got to move quickly to get something in place to deliver on what I've said. Thank you.
I hope you're all compiling your list of questions. Our next speaker is Professor Vernon Bogdanor, who is based here at the Institute of Contemporary British History, King's College London. Vernon.
Thank you very much. Ladies and gentlemen, Professor Tridemus said that he thought Brexit was the most important constitutional event in Britain since 1660, the Restoration. And I think that is right. And I think it's right because it heralds the introduction, or perhaps confirms the introduction, of a new principle into the British Constitution, namely the sovereignty of the people. Now, there's been a lot of discussion about the relationship between government and Parliament in drawing up Brexit. But I think the question that has to be asked is that, given it's the people who made this decision, will it be the people rather than government or Parliament that determine the shape of Brexit? Now, the Brexiteers wanted to restore the sovereignty of Parliament, parliamentary democracy, as one of the previous speakers has put it. But having succeeded, the sovereignty of Parliament is now undermined not by Brussels, but by the people in the referendum. it's an event, I think, without precedent for Parliament to be required to implement a policy in which the vast majority do not believe, and for a government to implement a policy to which the majority of its members are opposed. I can think of no previous occasion in British history when that has occurred. Now, the referendum was held, as the first referendum on Europe was held in 1975, because it was thought that our membership of Europe in 1975 and our continued membership today could only be given legitimacy through a popular vote. In other words, a parliamentary vote was not sufficient. And this is what David Cameron said. He said that consent to the European Union in Britain was wafer thin and needed further endorsement by the people. And it's a weakness in the doctrine of parliamentary sovereignty, which I think actually Dicey was fully aware of, that there are some decisions so fundamental that a decision by Parliament alone does not carry legitimacy. And in particular, any decision by Parliament to transfer its powers either upwards, as in the past to Europe, or downwards to a legislative devolved body, requires a referendum. And that, I think, is a very powerful liberal doctrine, because we elect people who have delegated power to make laws, but not to transfer the power to make laws to other people. So a referendum gives us a form of constitutional protection, perhaps the only form we can get in a system without a constitution, and which otherwise Parliament can do what it likes. It's a safeguard against major constitutional changes which the people do not want. And in this case, it enforces a constitutional change which Parliament does not want. And I suspect the future relationship with the European Union will be determined less by Parliament than by the people. Or you could put the point another way, and perhaps the constitutional lawyers will tell us which is right. You could say that the people, for certain purposes, have actually become a third chamber of Parliament for certain forms of legislation. It's not enough to have the consent of the Commons and the Lords, and of course the Queen, but you also need consent from the people. Now, there are various possible relationships which we can have leaving the European Union. The closest one to that is one which mimics the European Union, which is, broadly speaking, a Norwegian or Swiss relationship. And in my personal opinion, that you're in a worse position there than if you were actually in the European Union. But I think more important is to look at why the people have voted to leave the European Union. I think three basic reasons. Firstly, they want control over EU immigration. Secondly, they do not want jurisdiction from a European court, namely the European Court of Justice. And thirdly, they do not want to contribute to the EU budget. Now, all three of those would continue under the Norwegian arrangement and to a large extent under the Swiss arrangement as well. So people are unlikely, I think, to accept such an arrangement. The second sort of relationship would be some sort of trade agreement, no doubt desirable. Would take many years. The Indians are negotiating a trade agreement with the European Union and have been for 14 years. The Canadians for 7 years. That's not been ratified. As has been said, you require not only the consent of the European Union authorities, but also ratification by national and some regional parliaments, 36 of them. So it could be vetoed by the regional parliament of Flanders or Wallonia. And that leaves us with being reliant on World Trade Organization rules. And in that we broadly have two options. We can either retain the schedule of tariffs we already have, in other words, retain the EU common tariff, which in my view will not give the advantages we can get from Brexit in terms of freer trade, or we can improve those, or we can adopt a policy of unilateral free trade, which I think is probably the seems to me the most sensible outcome now. Some people talk of a fourth, indeed I think the Prime Minister talked of a fourth alternative, namely a bespoke arrangement specially suited to Britain. by which I think is meant an arrangement by which we get benefits of the European Union without the obligations. And I think any of you who belong to a tennis club might think that if you resigned from the club and asked if you could play tennis on the same basis as the existing members, you might get a rather dusty answer that you can't cherry pick and have an a la carte arrangement. And I think there are some Conservatives who still believe that the world rotates around Britain and that other countries, instead of following their own interests or European interests, are under some obligation to follow British interests. And I think we may find out that that is unlikely. There is one last point I would like to make, that we are likely to move into a world of freer trade outside Europe. People have emphasized the free trade elements of the European Union. It's actually a protectionist organization with particularly high duties on agricultural products and food products, and we therefore get cheaper food from the Commonwealth, and we avoid the CAP, and duties on cars of 10%, we can get cheaper American cars, that's what we want. But of course, most of the people who voted for Brexit did not vote for freer trade, they voted for the opposite. They voted for social protection, in particular protection against high levels of immigration, no doubt subsidies for industries that are in trouble, like the steel industry. Of course, many of the leaders of the Conservative Party who supported Brexit did so for quite different reasons, that they actually want less social protection and they want more globalization. And I think the paradox is that leaving the European Union exposes us more to the trends of globalization and world globalization than if we were still in the European Union. And it's the very people who voted for Brexit, named the left-behind voters, who will find themselves suffering the most disadvantaged, which means, I think, that the government needs to think very carefully about a radical skills program for those who are without qualifications or have minimal qualifications, who will be more exposed outside the European Union than they would be inside. And so I end with this further paradox that the people have voted, but they voted in a sense for something they didn't want. And this seems to me another paradox from the very remarkable referendum we've had. And it's said that constitutionally the most important event since 1660, I would say politically the most important event since the return of a Labour government in 1945, when one aristocratic lady who didn't like the outcome said, "The people have voted for a Labour government and the country will never stand for it." And that may be the same with Brexit. Thank you very much.
Thank you. Our next speaker is Dr. Helen Thompson, of the Department of Politics and International Studies at the University of Cambridge.
Thank you, John, and thanks very much for the invitation to join this panel. I'm going to make an argument about the political economy behind Brexit and its ongoing ramifications for the version of Brexit that one day will eventually ensue. I think that Brexit had its origins in long-term fault lines between the political economy of Britain's membership of the European Union and the essentially competing political economy of the rest of the European Union, or most of the rest of the European Union, that became inexorably and deeply bound to the euro. Put simply, I think Britain's membership of the European Union and its non-membership of the Eurozone was rendered unsustainable in the long term once the Eurozone crisis began in 2009, although there was no reason at all why the denouement of the problem had to be reached as early as it has been in 2016. And I think that what form Brexit will take also depends on the fallout of these continuing fault lines around Britain's rather singular political economy. Put schematically, I think the economic question then becomes, how does the EU accommodate as a trading partner a large neighbouring economy with a strong service sector and a large trade deficit, which acts as a partial employer of last resort for the periphery of the Eurozone and is in possession of the offshore financial centre of the euro? Let's start though by going back to the way things were before 2009. I think that if you go back to 2009, before the Greek crisis broke that autumn, that Britain's membership of the EU was odd, but it was politically relatively unproblematic, both in terms of British domestic politics and in terms of the EU's internal politics. Put simply, Britain had a collection of opt-outs. It had an opt-out on monetary union, it had an opt-out on Schengen, it had an opt-out on freedom, security and justice, and more flimsily, it had an opt-out on the Charter of Fundamental Rights. These opt-outs left Britain's membership resting on essentially two arguments. The first was the importance of membership of the single European market, and the second was, and I don't think this should be underestimated in terms of the view of the political class of this issue, the geopolitical influence that was taken to come from Britain's membership of the European Union, not least because of the importance of the US's support for Britain's membership of the European Union. This meant that in terms of the big European project that other EU states, particularly other large EU states, were engaged in, it was pretty limited and pretty, let's just call it limited in terms of the basis of Britain's ongoing membership. But crucially, I think there was reasonable political consensus to support this odd position as things are developed by 2009. What then happened was the financial crisis, but in particular the Eurozone crisis, delivered huge shocks to this status quo, and I think there are a number of them that I'd like to stress here. The first was that in dealing with the financial crisis, Britain had policy tools that other large EU states did not, and it had them by retaining a national central bank. The second was that the Eurozone crisis politicised, and in particular in France, London's position as the offshore financial centre of the Eurozone. This was something that everybody else in the Eurozone had plenty of reasons to object to, pretty much since the time it emerged in the early 2000s. But the Eurozone crisis meant that it became a much more significant practical political problem in those member states, and it particularly became a problem an issue in France. Thirdly, once the advantages of one, i.e. staying out of monetary union, came into play in monetary decision-making in 2011, Britain was able to move to a clear economic recovery, at least in the relative terms that we can talk about economic recovery since 2009, from 2012, while the Eurozone economies went back into recession. And the periphery of the Eurozone, as we know, descended into deep crisis. You can probably put that down to 2011 rather than 2012. In the fallout of that, so in the fallout of the return of the Eurozone to recession and Britain's recovery from recession in 2012, Britain became a partial employer, in fact some might say more than a partial employer of last resort for the most afflicted economies in the Eurozone. Fourthly, the consequence of this was a sharp rise in EU migration into Britain, particularly from the periphery of the Eurozone from 2012. If you look at the opinion polls and track UKIP's support with the increase in migration that comes from the periphery of the Eurozone, as the Eurozone crisis deepens in 2012, they track each other pretty well. This is what creates the political pressure in the Conservative Party that led to Cameron's promise of a referendum in the first promise made in January 2013. Fifthly, the particular threat to the city's position in euro trading and a more general willingness amongst the other EU states and the Commission to push policies to which the city was opposed becomes a particular issue again from about 2011-2012. You might argue here actually that things started to lessen in terms of the political difficulties the city was having over financial services once the referendum came nearer and nearer. But the pushback against the city's position as the centre of offshore euro trading complicated the interests of the city in relation to the single European market. Where the city had been relatively united about the benefits of EU membership, it became less so. Still, clearly the majority of city firms were strongly in favour of EU membership, but the strongest proponents started to become American investment banks in London. There started to be a clear dissident minority position within the city. Now, I think you can argue that all these developments stemmed in one way or another from Britain staying out of the monetary union, and that decision came in the fallout of what happened in the early 1990s and Britain's exit from the ERM, the exchange rate mechanism, although the political consequences of the immigration issue were very much amplified by the problems caused by the Blair government's odd decision to issue transition arrangements on the 2004 accession states back in its second term. These interrelated set of issues generated by Britain's political economy with the rest of the EU do not go away, I think, with Brexit. First of all, the euro poses a large existential threat to the European Union. It might be said, you could say, that there's a competition going on now between the risks of Brexit for Britain and the life-threatening problems of the euro for the rest of the Eurozone part anyway, of the European Union. But in this competition of problems, Britain has one absolute advantage. It can have a much more flexible macroeconomic policy than that available to any Eurozone state. That, in one way, I think, creates a strong incentive for the EU to be as hard as possible on Britain, to make it as difficult as possible for Britain to prosper from Brexit and to cash in on that advantage. Yet if that means insisting on hard Brexit from the European Union's point of view, that raises another euro-related problem. Pushing Britain entirely out of the single European market, i.e. making it too difficult to stay in terms of offering nothing on freedom of movement, means losing Britain as an employer of last resort for the periphery of the Eurozone in particular. That means putting a burden either on higher unemployment in the Eurozone periphery, or at least one more large state, or at least another large state, adding to its burden with democratic consent to the free movement of labour. And we've only got to look at, I think, what's happening in France to see that this is not an issue that is confined to Britain. I think it's also the case that other single European market questions are far from simple, either from the EU's perspective or from Britain's, and this goes back again to Britain's rather singular political economy. If we take the single European market itself, to all intents and purposes, there is no single European market in services, and this is where Britain's comparative advantages lie. In terms of services alone, Britain has much in principle to gain from what would be its capacity to strike new trade deals outside the EU, particularly since existing EU trade agreements with other states have been weak on services. Making this difficult for Britain by a slow process and complicating negotiations on other issues has got some attractions, I think, for EU states. It's more attractive, though, for those states that don't have a significant export sector tied to the British market, and for those that are not net contributors to the European Union budget, who will lose less from Brexit if Britain continues to pay a budget fee to access the single market. Now, of course, that excludes Germany. Germany falls into the category of a state that does have a significant export sector directed into the British market, and it is the biggest net contributor to the EU. Now, it has been a commonplace to say that this Brexit deal has to be negotiated with 27 states and the Commission, and of course it does. I would suggest, though, that the most cursory look at EU decision-making over the past few years suggests that when things really matter, there is one government that decides these things, and that the protection of the German trade surplus has been a reason of state in German macroeconomic policy for 50, 60 years, and it will be so even more now that the other reason of state in German macroeconomic policy, price stability achieved through monetary policy, has been entirely disregarded by the policies that the ECB has pursued under Draghi. And I think the correlation or the relationship between these two positions, between Germany, if you like, doubling down on the trade surplus in response to the ECB's move towards quantitative easing, can be seen quite clearly in the remarks that Schäuble made last week. Within Britain, the city's strong preference is clearly to retain existing passporting arrangements. Now, I think the city, which has lost, I think, in democratic politics for the first time since the 1930s, has a capacity in parliamentary politics rather than plebiscitary politics and referendum politics to exercise significant influence. Given the perception that, as Vernon rightly says, that free movement issues won the referendum for Brexit, and the problems that the absence of passporting from the deal will cause for the Conservative government in securing parliamentary consent to the final deal, there is much here, I think, as others has perhaps suggested, for the EU to exploit in forcing the British government under Theresa May to choose. But if the city does get passporting and does not have to adapt to finding a post-single European market role for itself, I still think the single European market is far from unproblematic for the city because of its position as the offshore financial centre of the Eurozone and the political discontent that that has created, as I say, particularly in France. At the moment, non-discrimination against non-Euro members in financial service matters within the single European market rests on one technically justified decision made by the European Court of Justice in 2015 as the referendum was looming, and it's not at all clear yet that that would apply to non-European Union members. So in this sense, the city's problems do not go away simply if they get what they want on passporting arrangements. Nonetheless, while the city issue, I think, has got the potential to cause a lot of short-term problems for the British negotiating position, the city as a whole, as opposed to groups of staff at some individual city firms, isn't going anywhere. Its strengths lie in the depths of London's capital markets, the integration of the services it offers, and the common law. And they cannot be replicated in any other European country. In conclusion then, Brexit was, I think, largely a long-term inevitability generated by a significant conflicts of interest between Britain's political economy and a Eurozone-dominated European Union general political economy, and it will play itself out against a backdrop of long-standing predicaments, not, I think, problems that can actually be solved. And there's two, I think, that I would just draw attention to in particular, is that the EU has moved to constitutionally guaranteed free movement of labour while retaining national democracy. I don't think there's any historical reason to think that beyond the short term, and they've only been in place in many genuine historical perspective for the short term, that these are compatible with each other. And in this sense, Brexit is a manifestation of this problem, and it is not going to be the end of it. The EU also moved to monetary union while one of its largest states with a strong attachment to national democracy and a premier financial centre with a long-standing tradition of offshore business, with a long-standing tradition of offshore financial business, as in the city, rejected it. And again, one part of that, in particular, the issue of the relationship between the city as the offshore financial centre of the Eurozone and the needs that the Eurozone has in order to put more integration in place to deal with the deep problems that the Eurozone faces isn't going away. I think that both sides now have to work out an alternative way of living with those predicaments in ways that avoid the consequences that were let loose by the Eurozone crisis, but without there being any guarantee that actually there is a way of avoiding the consequences that were let loose by the Eurozone crisis.
Thanks, Helen. And now our final speaker is Helena Morrissey, who is CEO of Newton Investment Management. Helena.
Well, good evening. It's a great pleasure to be here, and I'm conscious that you've all been very patiently listening to lots of different speakers. Might be wondering, is there anything more that could be added at this point? I'm not a constitutional law expert. I don't sit in the House of Lords, but I am a market practitioner, and I hope that I might have something. It'll cut across, and some of the points have been raised already, but I hope it'll be a slightly different perspective. Now, I will confess right up front, I know we're not discussing the merits of leave or remain, but it's important for framing my arguments that I did vote to leave the EU. So although I'm a member of a financial institution, I'm a city practitioner, I voted to leave, and I'll come on to some of the reasons why as I talk. But obviously there was a challenge thrown to those who were advocating that we leave during the referendum debates, and it was a fair challenge, although unanswerable really then and probably now, in terms of what leave would look like afterwards. And so I felt at the time that the EEA, EFTA or Norway model was at least a plausible first step and a reassuring opportunity. It's an off-the-shelf model. It would be a transition. It wouldn't be the final resting place for the UK, which obviously has a very different economy, but at least it would give us a start. I don't agree that it's the worst of all worlds, but that's sort of behind us now anyway, because clearly things have changed, and it's a woman's prerogative to change her mind, and so I'm changing mine too. But also, we are all learning as we progress through this. One of the very important points that has been made already several times is this is a period of uncertainty. There isn't a roadmap to follow on many different aspects of what we're dealing with here. Now, as a business person, that actually doesn't fill me with fear or dread. I actually know that often there is opportunity if one isn't overwhelmed by the uncertainty, but it does mean that one has to cope with taking one step at a time, that you cannot see too far into the future. I actually heard somebody this week saying, well, I can't believe it, the British government's sort of making it up as they go along. And I'm countered with, I'm not sure that there would be any other way of going about the challenge that we are faced with. So I am open as we travel through this and urge others to be as well, because there aren't any easy answers. So since the referendum, of course, the domestic politics have changed considerably, and of course the Prime Minister has made it very clear that she heard the message from the majority, albeit a slim majority, of the British people, particularly around, as Rich has already said, the desire to have more control over our own sovereignty and national democracy, and also the issues around control over our own borders. And it seems, of course, that therefore she recognises, and it'll be used, the term red line, I think we'll all have to get used to. Everyone will be talking about red lines on both sides, and the red lines will be some way off each other or contradictory for some time to come, that unfettered freedom of movement is not politically an option. So obviously, unless, which seems incredibly unlikely, the EU suddenly turns around and changes its very public and very obviously closely, dearly held view that free movement is a cardinal rule. Obviously at this stage that means inevitably that we're looking at negotiating some form of free trade agreement and skipping out that step that some of us thought would be a sensible first step along the way, i.e. let's go down the Norway model and at least then start dismantling our relationship over a longer period than 2 years. Now, so we know where we kind of stand in some of the red lines points. The question, and it's just been raised, Helen didn't quite use the expression sort of cake and eat it, or Vernon, I can't remember which one was talking about this, but obviously we're now into some of the thinking about what might we want that might be acceptable from an EU perspective. And here again, I'm braced for a lot of heat and light on this point over not just days, weeks, months, but potentially years. We obviously have in just a couple of, what date are we? Days, the EU 27, the other EU members meeting in Bratislava, and when they met immediately after the UK referendum, they came out with a pretty hard-nosed, albeit sort of in some ways conciliatory, talking about the spirit of partnership with the UK and hoping to still be good neighbours, but it's still, within that brief communique, it said very clearly that access to the single market will depend on membership of the single market. And I expect to see very similar language, if not harder, in the near term. But actually, I believe that, and I'm not a lawyer, but so I say this somewhat riskily, but I think that there's a confusion over what the single market is. Certainly in financial services, the single market is not yet complete. We know, because we were working on it, when Lord Hill was a commissioner, that we don't have capital markets union, and there are disconnects between how certain countries' products are treated from one country to another. What I think the single market is really, for me, one of the reasons why it has been problematic for me, seeing how regulation is set ahead of business interests often, is that it's not a single market, it's a single regulatory regime. And that if you want to have access to the member states and the people within it, the consumers within it, obviously, if you are a member state yourself, there are no questions asked. You have to comply, as is already clear from what Richard has said. That is the supranational lawmaking body, and therefore it's assumed there aren't questions asked, that you are compliant. If you're not a member, then you would have to demonstrate equivalence. And that's a bit of a headache for a lot of parts, certainly of the city. Passporting gets us around that. But it isn't completely even across all parts of the city. And I don't think it's a black and white sort of binary thing. Last time I checked, American companies were able to sell their wares on a pretty free basis into the EU. That we buy, obviously, things from non-EU member states. We'd expect them that expected to conform to our own, say, safety standards for toys. But it is more complicated than just having to belong, I think, to the single market to have access to it. And it's a very controversial point, perhaps, and I'm sure we'll discuss it in due course. But it does mean that if we were to not be part of the single market, we would not, and to really echo Vernon's observations about the EEA model, we would not have to accept lock, stock and barrel EU regulations. The numbers are all over the place, but the biggest one I've been able to find is that 6% of companies in this country trade with the EU, but obviously 100% of companies have to abide by EU regulations. Now, in fund management, I'll give you one very specific example. We currently manage, collectively in the UK, for UK-based firms, around 800 billion pounds of money on behalf of, or funds on behalf of EU clients. But most of us already, I mean, the UK is not the fund domicile of choice. Most of us have a fund range in either Ireland or Luxembourg. We currently have delegated authority from the actual fund management companies in those countries to effectively manage, it's called advising, but we manage the money. And we could have, may not be as simple as I'm making it out, a bilateral arrangement with, say, Ireland, who I'm sure would be very keen and eager to do one with the UK. If we weren't allowed to have access, then it's not a zero-sum game for the rest of the EU. We provide effectively a big turntable of capital for the EU. We are investing in EU companies. EU clients are taking advantage of skills that we have in London that wouldn't necessarily rush over to live in Frankfurt or Paris. A lot of that money might go to the US, for example. Now, I'm not saying that the EU may not cut off its nose to spite its face, but I think we go into the negotiations acknowledging that there would be reciprocity of access. And of course, in aggregate, the UK, that's leaving aside the city, but even including that in the numbers, the UK has a very big trade deficit with the EU, i.e. they sell much more to us than we do to them. Now, since the referendum, of course, and in advance of referendum, a couple of points that haven't come up yet, but if I can use a few minutes just to make them. There was obviously a lot of scaremongering. We're all going to Helena handcart. It was all going to be a complete disaster. And obviously in the immediate aftermath, and on an ongoing basis, I do not wish to gloss over the very significant, as the Prime Minister described it, sort of, there may be difficult times ahead, but, we're all still here. The FTSE is up quite a lot. The pound has fallen, but that has not been bad for returns if you have global investments, and it makes us more competitive as a country. And of course, people are now starting to think in the city about, is there some, and it might sound a bit cake and eat it, but we are resilient. We were around long before the EU was invented, created, and now people are starting to think about what might be the opportunity set. We see our competition not really as Frankfurt and Paris, to be honest. We see it as New York, as Singapore, and as Hong Kong. London is currently the top global financial center, not because of one factor or two factors, but because it's a big cluster for expertise. Obviously, we have the just luck of the draw in terms of having English as our language and the time zone as well. Paris is number 32. And when we didn't join the euro, of course, there was lots of talk that everyone would move to Paris or Frankfurt, and they didn't. So I would urge a little bit of taking that with a pinch of salt. If we take it one step at a time, we don't try to see where we are in 5 years' time, then I'm pretty confident that we will be able to get there, not just in one piece, but in a way that is thriving. Thank you.
Thanks, Helena. Okay, so you've heard from our speakers. Now we want to hear from you. We have someone with a mic. So conveniently, there's a question right next to you, Konstantinos. Can I emphasize, though, that we'd like questions rather than speeches, and that people should keep them short, and also perhaps tell us who you are before you begin.
Hello, I'll try and keep this as short as possible. Lord Norton and a couple of other speakers mentioned that Article 50 would be the most appropriate way in the way that the government thinks we should exit the European Union, but the specific wording of that article mentions in accordance with the state's constitutional requirements. Now, given that there was no clause in the original legislation that provided for a referendum that said that it must be upheld, would it not be the case that Parliament must pass further statute in order to make this a constitutionally binding act?
Do you want to take that?
Yeah, sure. The short answer is our view is yes. That was part of the report we produced yesterday. We think it's appropriate for that purpose. Whether it's essential is a matter of dispute, but we think it would deal with the very point you've made, because then it would put it beyond doubt that it's gone through the necessary constitutional processes. That's why I say it would not be seen as a challenge to government. I think it would strengthen its position, because then the process has been gone through. So that's why we recommend that we should actually pursue that particular route. As I mentioned, statute would put it beyond doubt that we've complied with that.
Anyone else?
I mean, I agree that Parliament could add further constitutional requirements. It's a bit odd to do it now, but it could do. And it might be a good idea to strengthen the government's position if it wanted to delay matters, to say, here are the further conditions Parliament has insisted on. These are our requirements, our national constitutional requirements. But in one sense, I mean, the point of that part of Article 50, I think, is just to say it's up to the member state. And so there's no live prospect, I think, although an EU lawyer might correct me, that if the Prime Minister does exercise the prerogative and convey Britain's decision to leave, that it will be challenged in the European courts that we've failed to follow our constitutional requirements. Maybe that would happen if, and probably would happen, if the Supreme Court said, no, you need an act of Parliament, and the Prime Minister said, well, I'm going to make the notice anyway. And it's actually a tricky question there as to, you know, the Crown has the capacity to represent the United Kingdom at international law, and even if it acted illegally as a matter of domestic law, it could still do so effectively at international law. Now, that's not a good idea, and I doubt it will happen, but those are the relevant considerations, I think.
More questions?
Right at the back.
This question here.
Thank you very much. Lord Norton, you mentioned the Fixed Term Parliaments Act, and I wondered what you thought of the proposal that was introduced, the bill that was introduced to the House of Lords last week about repealing the Fixed Term Parliaments Act, and whether you thought it had any legs, whether you thought it was a desirable development, especially given the current tensions between the executive and parliamentary power, and where you think that would lead.
Right. I mean, it's got nothing to do with Brexit, but how long have you got? The problem with the repeal measure, there has been a private member's bill that provides for the repeal of the Fixed Term Parliaments Act. I have pointed out that if you simply repeal the Act, then you introduce the potential for Parliament to continue in perpetuity. Because you've got to decide what you replace it with. If you don't, there's no provision for election or anything, unless you argue the prerogative bounces back, in which case you rely on the Crown at some point to decide, oh, we'll have an election. So you'd need to replace it with something, so you can amend it, but you could bring in a new act to stipulate the provisions in which a future elections could be held. Now, you could try and put it back to what it was, but you'd still need to stipulate that in the Act, because the Septennial Act is repealed. It was repealed by the 2011 Act. Section 7 of the Parliament Act, 1911, was repealed. So they're gone. So you'd have to put something back if you wanted to revert to the old practice. There is quite a view in Parliament that that would be appropriate. When the Fixed Term Parliaments Bill was going through, a large body of those who were voting for it were not doing so with great enthusiasm, as one of my colleagues put it, voting for it through gritted teeth. And it ran into some problems in the Lords, because what the government was doing as a coalition government was effectively legislating. It was a short-term fix that was going to be continued in perpetuity, so we weren't quite sure why it wasn't just confined to one particular parliament. So there is a general view, it's not, there's something of a strong view, I think, among many parliamentarians it should be replaced. There's probably a view that trying to go back to what was, the problem is getting from here to there and actually introducing a measure to give effect to that. It would need to be a government measure, and I don't see any enthusiasm on the part of government at the moment to do that, not least because it's slightly distracted by other things.
This question over here.
Eloise Scotford, King's College London. This is a question for Professor Bogdanor. The suggestion that there's a new constitutional principle of the sovereignty of the people. I quite like that idea. My question is, are there conditions around which that sovereignty is validly exercised? Is validly exercised? For example,
yes.
Lord Norton's suggestions about the number of
I think we've developed in a very pragmatic and unplanned British way certain inventions as to the use of the referendum. I think firstly when a new form of political machinery is introduced, like directly elected mayors, at least until recently it was held to be a referendum was needed, a new political machinery like a new electoral system, for obvious reasons a referendum needed, but most important in this context, the transfer of the powers of Parliament one way or the other, upwards or downwards. And that leads me to think in relation to the Brexit question that the issue of whether we end up with perhaps a Norwegian type solution or something similar to that will not be solely for the government and Parliament to decide, that the popular pressures will be such that they will want the logical consequence of the referendum to be followed, namely that we have control over EU immigration, there be no control by a European Court of Justice or the EFTA Court over legislation in Britain, and that we make no contributions to the EU budget, which of course the EEA members do. So my strong political guess would be that the referendum, the sovereignty of the people having asserted itself, will also shape the final outcome of the process. And as I said, it's a process government and Parliament don't want to be involved with. They're doing something they don't agree with or believe in. They're required to do it by an outside force.
I was just going to add as well, you might want to look at the Constitution Committee report back in 2010. We actually did a big report on referendums and addressed this problem that in the United Kingdom, since there is no formal requirement as to when told it when to not, to identify those issues on which it would be appropriate given where we are. Our starting point was that a lot of people have got principal objections to referendums, but the problem is succeeding governments have not. And so once they've started to be part of our constitutional framework, we need some sort of rules to govern them and decide on what issues. So we've gone some of the way, but I think the referendum, the June referendum, also suggests we need to do far more to consider what are the conditions under which we hold referendums, not least things like should there be thresholds. Quite a lot of nations stipulate when there should be a referendum, but also require, say, a 2/3 majority of those voting. So I think one of the points we make, we've got to revisit it. We've done a lot of the groundwork in looking at referendums, but what happened on 23rd of June, I think, stressed the need to look at process, and of course what happened raised a quite fundamental question as well about accountability. If you don't like what happened, who do you hold to account?
Can I make one further point? This referendum also establishes a new constitutional principle in the European Union, namely that if you vote no, it will have an effect, because in the past, when people have voted no, they've had a second referendum till they voted yes. This is the first occasion, I suspect. It could be a change. It's possible, but it's the likelihood is this sets a precedent that no actually means no, and that when you say no, you don't really mean yes.
Okay, there are some hands at the back there, so if we could. I think Dr. Hestermeyer.
Thank you very much. I'm also intrigued by the notion of the changing constitution and popular sovereignty. And particularly the interpretation, because you, as you rightly said, the action will now be driven by the interpretation of the referendum. But actually, when I look at the panel, and if I remember correctly, the interpretation on the right was the EEA would not be what the referendum wanted. Then slightly to the left, I voted leave because at the time I was thinking of something like the EEA. And then there was the interpretation, there are 3 separate elements that the population wanted. But additionally, you could say there were people who voted in the referendum leave because they wanted more workers' protections, others wanted less workers' protections, some wanted free trade, some wanted less free trade. So isn't the better view to say the meaning of the referendum is limited to what the question asked was, rather than then interpreting, or if you say it's interpreting, then how do we interpret the meaning of the referendum?
Who wants to take that?
Well, I think the EEA is much misunderstood. Firstly, it's a home for countries that were contemplating joining the European Union, a halfway house for those joining, not for a country leaving. And in it, you have almost all of the obligations of the European Union. You accept not only the current acquis, but the whole future acquis that the European Union decides on without having the slightest influence or minimal influence on what it is. It's very akin to what the American colonists complained about in the 18th century, that decisions were made for them by the British Parliament where they weren't represented, and people said, well, you're virtually represented because the British Parliament takes account of your interests. And that's what happens if you're in the EEA. The EU virtually represents you because the EU takes account of your interests. Now, the only people in Britain who are virtually represented are children who don't vote, and they're represented by their parents. Now, it may be all right for a small country like Norway, which has little leverage in the international system anyway, but can one really imagine Britain being in that position? It's really quite extraordinary, and I think much misunderstood. That all the 3 things I mentioned you're still doing. You're still paying into the EU. You still have to accept free movement. Norway, in fact, in the Schengen Agreement. And you're still subject to the jurisdiction of a European court, not the European Court of Justice, but the EFTA court and the EFTA surveillance authority. And you're not actually in the organisation. Now, is this a position that anyone really wants to be in? It seems to me not.
I just wanted to interject, no offence intended to our Norwegian viewers.
Yeah.
Well, the Norwegian...
I just want to chip in on 2 points. One is, I think, gentlemen, you're making the point that people voted for different things, effectively, and I think that's why Leave won. I mean, I think it's as simple as that. I think the people, it was the opposite of when your vote gets split between when you kind of both, they're standing for the same thing, but they don't, the other guy gets or woman gets through because that split the vote. This time they got the votes of people like me who wanted our sovereignty back. They were the people who didn't want immigration. And so they won because they got different reasons that had been a flaw if you were on the Remain side. So I agree with that if you were trying to narrow it down. You might want to come in on as well. But just on the EEA, I didn't vote to leave because I thought the EEA was a wonderful model. I mean, it was more that I thought, just to clarify, that it was a safe first step, and it would answer the question in terms of there's no one has any idea what we would do if we vote to leave, and that could be a step if given this 2-year time frame. I do think the point hasn't been made yet that is important, that one reason why Britain is in a different position from Norway, say if we were, all that talk about governance by facts, that we would still, a lot of lawmaking is made at a global level. The EU, from what I can see, again, I'm not an expert, is often a taker of law or regulation from certainly on a financial system basis. A lot of standards are set globally, and rather than being the decider of it. So, and the UK obviously has a big presence. Mark Carney is chair of the Financial Stability Board that was set up after the global financial crisis. We play a big role because we have excellent lawyers. This is evident from this room. Everybody a lawyer here. No? So I think, just to clarify, EA was not in nirvana at all. It's just that it was somewhere where we could go to start with while we worked out this very complicated arrangement that we're now embarking on.
Can I just add something? Sure. I kind of agree with you in the sense that I don't think anything can be read into Leave in terms of motivation beyond the question on the ballot paper. And while I entirely agree with Vernon that this is a massively constitutionally significant moment because the sovereignty of the people asserted itself, I think we've now reverted back to parliamentary politics. And I don't think that plebiscitary politics comes back in terms of the deal that will, or whatever the terms of Brexit will be. I think the problem is that it's occurring in a context in which British parliamentary politics is in crisis because of the crisis in the Labour Party. And so that what would actually happen if that wasn't the case is that you would have a contested election in 4 years' time in which the different parties would take different positions around the different cleavages that have been generated by Brexit. But if you have one of the parties that cannot fulfil its basic parliamentary position as the opposition party and is all over the place and not beginning to get to grips, I think, with what Brexit means for its own voters, then that dynamic is going to be incredibly difficult to see how it plays out.
Richard, did you want to address the content of the mandate?
Very briefly, yeah. So I partly agree with the proposition and the question. Namely, the most important thing is the question asked and the answer given to that precise question. And the more that it leaves open, the more that's open. But you do, I think, have to make something of whether there were some reasons for doing so, whether those reasons are widely shared. And the answer might be, there's just nothing here. There's no sense amongst the voters, the electorate, that there are some central concerns that make some sense of what's gone on. But I think in a way that's just a rival interpretation of the sort of remarkable event that was the referendum campaign and then the actual vote itself. And parliamentary politics has to make something of what's gone on. And an explanation might be better or worse. And the explanation might be, all we have is a bare decision, so we're going to barely comply, and you can't say we're cheating you. And that might be fair enough. Or it might be, we've got to comply in a way that is responsive to some of what makes sense of what was live. And that could be, I think that's partly an incomplete agreement, namely there are some central concerns and yet behind them are a great many different visions and hopes and inconsistent ones, which is sort of unsurprising if part of the shared point is sovereignty and then we'll do very different things with our sovereignty when we've got it. Thank you. I think that's coherent.
Okay, Henry. Question in the middle there.
Hi, Henry Newman, former government advisor. If you were advising Theresa May, what would you suggest should be the red lines that she holds secretly but ultimately pushes for in her renegotiation? It's the whole panel.
Well, I mean, if I may say so, I think that question implies that we have more leverage than we have. Once you trigger Article 50, you are out in 2 years. And therefore, unless it's extended, which requires unanimity. Now, after that 2 years, unless you have a trade agreement, which is not going to happen within 2 years, clearly, you are then governed by WTO rules, and you place your tariff schedules before the WTO. And as I've said, you have really two alternatives. You can either continue with the tariffs you had within the EU, which would probably be accepted, or you can reduce them at the extreme, which I think is a case for unilateral free trade. Now, of course, that doesn't cover services and all the points that Helen has made of great importance to the financial world, but I can't see that Britain has very much leverage. And if Cameron didn't have sufficient leverage to secure things that the public wanted when he was in the EU, I mean, it's unlikely we're going to get it when we're out of the EU. And the further problem, which hasn't yet been mentioned, that if Britain got the sort of bespoke deal that some people were talking about, which gives you the benefits without the obligations, Marine Le Pen will say, well, look, France wants the same. Why can't we get it too? We can leave the European Union and get those benefits. The Hungarian nationalists, the Swedish nationalists, they'll all say that. And the EU, from being a kind of multilateral organisation, will become a series of bilateral bargains. So I think our leverage is much less than some people are happily admitting. I'm sorry to pour a bucket of cold water on this. Perhaps it's easier for academics who aren't involved to do that, but I'm not sure Britain's in a position to draw any red lines. Actually.
I think that I'm not sure whether I would answer the question about red lines, but I think there is some leverage on 3 counts. The first of them is articulated quite forcefully, actually, in a piece that's in Der Spiegel today about the issue of net contributions to the budget. The Germans have worked out how much this is going to cost them in terms of net contributions, and it isn't pretty from their point of view. The second thing, and goes back to the point I made earlier, is Britain has acted as an effective employer of the last resort for the Eurozone crisis. Unless you think the Eurozone crisis is going away, then this dumps a problem on some other member states if Britain entirely leaves and falls back on WTO membership. And then I think that the way in which the French situation with the election, the way in which the Italian banking crisis may play itself out over the next 6 months or so is also going to affect, because at a certain point, the EU is going to have a much, much bigger problem than Brexit on its hands. Brexit is going to seem like, you know, a walk in the park compared to the problems that are going to be generated by the pressures that will be put on the Eurozone over the next 2 years or so. And in that sense, I think that it's actually difficult to see how things are going to develop, because there's such a big unknown about the political context at the EU level in which this will be negotiated.
Anyone else want to talk about the red lines? I take it by red line you meant not what we can make the EU accept, but what we should not accept, but rather instead default to WTO rules. Anyone?
I'm not sure that they are or should be secret, but free movement of people seems a difficult proposition to accept in light of the explanation for the referendum we've had, and likewise integration in the EU legal system. I mean, I don't mean keeping equivalence with various standards. I mean the sort of involvement we have now in the legal machinery of the EU.
Any other red lines?
I'm not imaginative enough, sorry.
Yes, question there. In the middle? The lady there in the middle?
Hi, thanks very much for the great talk this evening. I have a question. I'm just wondering about Scotland. Sorry to bring it up, but I know that Nicola Sturgeon has already started to make preparations for a second independence referendum, and as someone who voted to keep the UK together, I'm just wondering, is there a realistic, constitutionally, is there realistic prospect if Scotland should decide that they do not want to accept any treaty negotiation or settlement that Westminster Parliament comes up with? Is there anything statutory based which would allow them to reject any sort of decision in that way and therefore keep themselves from being removed from the EU, as it were?
I think the answer to that is no. I mean, we're required to consult with the Scottish Parliament, and I think it's called a legislative consent order, is the term, but it doesn't give Scotland a veto. Some people have talked of what they call a reverse Greenland, which sounds like a rather painful kind of judo position, but actually isn't. What they mean is that Scotland could somehow stay in the EU when the rest of Britain left, by citing Greenland, which left the EU when Denmark remained in 1985. But that's quite different, because Greenland leaving didn't alter relationships between an existing member state, namely Denmark, and the rest of the EU. It was a small part of the country leaving, just as the Channel Islands, for example, don't belong to the European Union, various bits of the French and Dutch empires that were left over and so on. But this is quite different. You couldn't have 10% of a country as the continuing member state. That wouldn't be possible. But I think the Nicola Sturgeon's a master at sort of smoke and mirrors. And if Scotland wanted to remain in the, or to apply to join the EU after Britain left, she'd have to apply on the Article 49 procedure, which would require her to join the euro and thereby reduce her budget deficit to 3%. It's now 9.5%. And with the falling price of oil and the working out of oil is likely to increase as time goes on. She wouldn't, I think, get Margaret Thatcher's rebates either. So I think that is not a strong possibility. And it would be, if unless Britain had a very soft Brexit, there'd be a border control and a tariff between Scotland and the rest of the United Kingdom, which means the rest of the United Kingdom, Scotland's main trading partner. The main difficulty, I think, in regard to the cohesion of the United Kingdom is less Scotland. I think that is a non-issue independence, but I think the issue of Ireland and the problems of what happens to the common travel area and a tariff on that very difficult to police border is an extremely serious problem, and I can't see how that can be resolved.
What was the reason that 10% of the country can't stay in the EU?
Well, because it's clearly not the continuing member state. The continuing member state can't be 10% of a unit.
Apparently there are some complicated arguments that people make. leave it. Any further?
Well,
No, I agree. I think the answer is no, but
yeah, sorry, yes, I agree as well, because I mean, Vernon's absolutely right with his first answer. The answer is no. I mean, you've got distinction between the constitutional position and the political turmoil that has been created. But constitution is the United Kingdom doing the negotiations. Scotland doesn't have any formal role. You've got the Sewell Convention, which the government's put in statute in a way that's actually constitutionally a nonsense, but it includes the words normally. And this is not a normal situation. They get round it that way. So no, Scotland will make Nicola Sturgeon will make a political issue out of it. The Prime Minister's been quite adept in already going up to Scotland to indicate to the different parts of the United Kingdom she wants them to be involved, but none have got a veto in the process. And Vernon's actually absolutely right about the position in Northern Ireland, the relationship with the Republic. The government's already very alert to that and already pursuing it.
I was alluding to an argument to the effect that France, for example, has some territories in the Pacific that are not part of the EU.
Yes, that's right.
So the UK could stay within the EU and regard England as one of those Pacific territories. That's the analogy. But,
no, but they're small bits and pieces, like the Channel Islands. They're not
part of the UK. They're overseas territories.
What are they going to say?
I was just going to say the answer to that is no. I just don't think the analogy stands.
okay. Yes, back there. The lady back there, next to the pole. Thank you.
Hello, good evening. I'm Daniela Fetugayonsi from King's College. I was just wondering, you mentioned that when Article 50 is triggered, that there are going to be 3 ways of doing that. Of course, there's a withdrawal and the start. But then you also mentioned that a part of those people who are going to take part, people are going to be the 3rd member. Could you please elaborate more what you meant about that? You said that people are going to be the 3rd member in terms of that negotiation.
Third chamber.
Third member of the House, third member of Westminster.
I think it was the people as the third chamber. Is that right?
No, I raised the question that are the people becoming, for some issues in practice, not legally a 3rd chamber? We have had mandatory referendums. I think the alternative vote one was mandatory, and it wouldn't come back to Parliament if there was a decision to change the electoral system. I think the one on Welsh primary legislation held a few years ago was mandatory. This wasn't mandatory, it was advisory. Though in practice, if there's a clear majority on a reasonable turnout, I think it's a distinction without a difference. But I don't know how you describe that, whether you describe that as the people becoming a 3rd chamber of Parliament, or whether you describe it as the people being sovereign as against Parliament. And I'm not a constitutional lawyer, perhaps the constitutional lawyers will tell me the answer. But it does seem an introduction of a new principle into our constitution, because up to about 40 years ago, before 1975, the referendum was thought to be unconstitutional, and it's now constitutional, has played a great effect in British politics. Without the referendum, it's possible we might be in the Euro, because Tony Blair wants us to join. But I think there's not been a single opinion poll that showed a majority for Britain joining the Euro, so we have something to thank the referendum for, I think.
And there was a question there from the gentleman just in front of you. Yeah.
Yes, Chris Bowman. Hasn't everything we've heard this evening suggests that Article 50 is completely not fit for purpose, and that the crucial priority for a British government which wants to do Brexit properly will be to finesse Article 50, either by delaying it as long as possible or getting some agreed transitional arrangement. Article 50, literally written down, would be a disaster in terms of timing and negotiating leverage.
Well, Article 50 is designed to make it difficult for people to leave. Until the Lisbon Treaty, there was no constitutional method of leaving the European Union, and that was put into the Lisbon Treaty. But you know, if you belong to a tennis club and you think the tennis club's a good club, you don't want to make it too easy for people to leave. I mean, it's designed to make life difficult for someone who wants to leave. And I don't know how we can, in honour, really renege on that. I mean, the public have made a decision, and in due course, Article 50 must be invoked. I think the European Union would like us out before the next European elections of 2019. I can't see any way to finesse that. You can, as people have said, it's clear, you can withdraw your invocation of Article 50 before the end of the 2 years if you change your mind.
I mean, the Constitution Committee took the view that the Article 50 route was the only viable route for actually withdrawing, but as Vernon said, it was written in a way to deter states from leaving, and was written on the assumption it would never be used. And we're now in a situation where there are people disputing authorship of Article 50.
I mean, there isn't a deadline or there isn't an expiry date by which we have to invoke it, is there? I mean, in theory, we could take a while, or it's not, I mean, obviously politically it might not be acceptable, but there isn't a drop dead. And the onus is on us. I mean, it's our prerogative when we invoke it.
I think that's right. There is no deadline, but undue prevarication, I think, is going to
It'd be
cause
counterproductive.
some kind of political problem, I suppose. And one could think of extreme cases where there could be legal implications, but we're not there, nor will we get there, I don't think. But I think I would. I mean, I agree that Article 50 was drafted in a situation where it wasn't really thought it would be used. But I'm not sure I agree that it makes it difficult for a country to get out. It is difficult to get out if you're in an organization like the EU, but that's not because of Article 50. Article 50 does give you a sporting chance. You can determine if you want to get out, when you want to do it, and the rest, as I said, I think it is politically neutral. It bows to the country that has more political power. So I don't think, I mean, comparing it in other words with other withdrawal clauses, I think it is, I would say it is a mild one.
Well, perhaps I didn't express myself clearly. What I meant was it gives the departing state very little leverage because of the 2-year time limit. And it's fair to say, hope not unfair to say, that most of those who want to finesse it in some way or don't like it is because they don't like the decision the voters made. But I mean, I take the view that I was myself a Remain voter, but I take the view now the decision's been made. Personally, I think the quicker we leave, the better, and adjust ourselves to a new situation. It's not one that I supported or wanted, but the British people wanted it. And there are lots of general elections where I don't support the decision the British people have made, but one has to accept it. And I think most of those of us here, I think, who belong to the elite, the exam passing classes, don't like the decision, but it's been made.
Yes, and sorry, I was just going to say, I think Article 50 does impose certain hurdles that actually limit it, including if you want to extend the negotiating period, because normally you'd wanted to go beyond 2 years, and any member state can basically say no, and that's it, you're out.
Well, that's correct, but I cannot envisage having a withdrawal clause from such an organization that gives you the right to leave without any process. I mean, that would just not be that would be a non-starter. So we don't judge Article 50 vis-a-vis that. We judge it among a range of possible withdrawal clauses, and that's what.
The world, do you see it as an ad hoc thing, or even in a business sense? How do you see it pan out going forward? Is it a change in society because of the big delta between those who want to stay and those who want to leave, or is it just okay, it's happened, now we're going back to business as usual?
Well, I'll start. I definitely think that it's symptomatic of a broader shift, and see, Helen articulated very clearly some of the background, and I think we're seeing, obviously, around many parts of the Western world, obviously we're seeing a lot of trauma in the political machinations in America. We're seeing, talked about France, Italy, the rising of populism, and I think it would be a mistake to think these were sort of ephemeral kind of moments. There's, I think, a very big shift. People and the internet is partly to blame or to credit for it, because power is less sort of, command and control. and more shared, and you have to earn it and be influencing, and we have the transparency of information. Every week there still seems to be a major scandal, and you think, how could the politicians be so stupid as to think they would never get caught out, because everything is discoverable. And I don't think our ruling elite has really adjusted to that shift, and this came as a shock to many people, because they thought, I mean, I've sat at meetings in the city where I was obviously the only person that was on the Leave side, and I heard the Remain saying they were listening to very thoughtful analysis about people having focus groups and explaining that the arguments about the economy weren't resonating, and instead of saying we must change the message, they said we must shout louder. I mean, it's a sort of arrogance that's gone with this that has, I think, created these waves, and it's symptomatic, not a one-off.
I agree very much with what Helen has said. I think it's a very important point, and I would hold perhaps a counterintuitive view that the referendum was a tremendous exercise in democracy and showed the democratic health of the country with an extremely high turnout, higher than we've had since the election of 1992. Many people who didn't vote in recent general elections turned out to vote. Many of them living in safe seats where under our electoral system they have very little leverage. And on the whole, people who perhaps life hasn't treated necessarily very fortunately. And nevertheless, they use their democratic rights. And in a sense, people who are badly off only have the vote. I mean, if you're articulate, as we all are here, you don't need the vote. We have other ways of influencing opinion, but the less fortunate only have the vote, and they did use the vote. And I think we are, as perhaps Helena implied, moving into a very different phase of democracy in which party government becomes less crucial, and popular government, direct democracy, has a greater role. I mean, democracy is still quite a young system. I mean, universal suffrage for men and women was over 21, was not introduced in this country until 1928. It was comparatively recent in historical time, and it may be the system we're used to is just one phase in the development of democracy, and that the implied the sovereignty of Parliament is being gradually going to be replaced by the sovereignty of the people.
I feel a number of people want to join in on this. Richard?
Yes, if I could just, so the principle of the sovereignty of the people has been mentioned several times. I don't agree, actually, we have a new principle of our constitution. I think we've got a serious political event that requires addressing. And I agree with much that Vernon just said about this being a pretty significant democratic moment and requiring recognition as such. Referendums are not that novel in one sense in the British tradition. If one looks more widely, they're pivotal to the whole story of the Australian Constitution and the New Zealand Constitution in part. And they're a technique that a representative democracy can make use of, an intelligent technique. And for, I think, in many of the situations Vernon referred to before, where the question is the identity of the state or the design of the electoral system, and so forth. So I don't see really this as a wholesale replacement of our representative democracy with a plebiscitary one. But we do have more general features or factors going on, a weakening party system, a rise of distrust of authority of all kinds, but political authority in part. So the politics are changing, I think, but I don't see that as somehow the Constitution having been reformed.
Well, I'll give a slightly different slant to this. I mean, Dicey, of course, distinguished between legal sovereignty and political sovereignty, and political sovereignty was exercised by the people, but it was exercised through Parliament. Now, what will happen in light of this, I don't think governments generally will think, oh, that was a wonderful exercise in popular sovereignty. Governments normally only call referendums, and this is specific to the United Kingdom. Governments normally only call referendums when they're fairly sure they're going to get the result they want. Now, given that that's not happened this time, it's quite a shock to the system. So what you're going to get, I suspect, is far more rigorous rules about the holding of referendums, whether there should be thresholds, and government's been far more wary about rushing into referendums and promising them. So I think there's going to be perhaps a slight, therefore, clash between all those who now call for a referendum on a particular topic, given what's happened here. So you might get that clash, people demanding it. Government's been quite resistant, and you're going to have a problem from a parliamentary point of view, for the reason I touched upon earlier. Because if people start demanding referendum and don't get it, and it's left to Parliament, they'll see this as somehow delegitimising Parliament because it's not been subject to a referendum. So the sooner we get clarity on the rules that apply and people accept them, the better.
I think that we have to see this moment both in terms of what's going on in the world more generally in Western politics, in terms of a reaction against elites, and we can see that in the reasons that Helen has said in across the West. And I entirely agree with Vernon. I think that we should think of this as a democratic moment that should be affirmed in some sense for the reasons that he said. But I think that this has going back long beyond the history that I was just talking about, a much longer history is there is a tradition in England in particular of the people, in some sense, however that manifested itself, reacting against the executive who it thought, the people, I mean by it, thought was far too committed to continental European affairs and world affairs generally, and not enough interested in what went on at home. I think you can see that, you can put the Peasants' Revolt, you can put Simon de Montfort, you can put parts of the Civil War, you can put going on further into that. And often it's been conducted in the name of liberty. The same kind of arguments that you can see that were made. It has historical resonance because there is a tradition in this country in which the court, to use an old language about it, has exercised power from the centre in ways in which the provinces has not liked very much. And they particularly don't like it when they think that it's being done at a continental European level and it's not focused enough at home. And this moment, although it's part, I think, of a broader moment in the West, fits into a historical tradition in England in particular as well.
Great. Time for one last question here at the front.
Luke, going on to the legal issues for a second. So after we've invoked Article 50 and the 2-year time period is up, we know if, say, negotiations fail, that we'll revert to WTO trade relationships. But what happens to our laws? So if we've got laws like referencing European bodies or European regulators, how does that work after we've left?
Well, we had to do what the Indians did when they became independent. What they did, they incorporated the whole of British law and then decided which they wanted to keep, which they wanted to modify, which they wanted to repeal. We'll have to incorporate the whole of European Union law. This is why it doesn't make any sense simply to repeal the European Communities Act. We have to incorporate the whole of European Union law and then decide what we want to keep, which will be some of it, no doubt, what we want to modify, what we want to repeal. That'll keep Parliament and government busy for many years and stop them getting up to any other mischief, perhaps. I mean,
well, I agree with that, apart from the last bit. It will keep us occupied. We need to think about the process. Vernon's absolutely right. My assumption is we'll need an act to keep the European Communities Act in place until such time as we start removing those laws we wish to remove. As I mentioned earlier, we've got to decide how much of that is through primary legislation, how much we can hive off and do it through secondary legislation to make it manageable. So, as I mentioned earlier, that is the heavy lifting from a parliamentary point of view. It will really keep us occupied, it probably dominate, but not to the extent we can't get up to other mischief.
Can I just add to that? I think the legal situation is extremely complicated anyway. Were we to get out at the end of the 2-year period without any transitional arrangements, it would be a complete mess. Even the WTO membership is not straightforward. At the moment, the UK is a member of the WTO in a dual capacity, in its capacity also as a member state of the European Union. So things are less, even those which appear to be straightforward are not. There will also be quite a lot of issues regarding, obviously, transitional provisions for businesses and individuals, and also issues about the location of EU agencies. I don't know. If we didn't have an agreement, there would need to be some kind of unilateral transitional measures from the UK and the EU, which one hopes would correspond with each other.
Maybe I can just say that I think in the first instance you're going to have continuity, as was said. You'll just maintain things. And you'll cancel and you'll amend them as time goes by. But you don't, I think, have to conceive of Parliament as now necessarily involved in a sort of 20-year law reform project or 50-year. It can just change things from time to time as it thinks warranted. So in one way, what will happen is a great expansion of the scope of lawmaking and policy making. It doesn't have to involve we're going to reform everything now, or reform everything continually until it's reformed, and then we can say, all right, we've done it. Changes, I mean, many of the laws presumably we will want to maintain with tweaks and so forth. So it just changes the scope of policy making and lawmaking. It changes it radically, but it doesn't require an ongoing law commission to do the job necessarily. You could do that, but it's not required.
I think that's correct, and I don't think it could be done very quickly. But even then, there would be problems. For example, insofar as, by virtue of British legislation, the existing legislation which is based in EU commitments is maintained, there will be some questions about the status of the case law of the European Court of Justice. If we are applying the same rules as the EU, does the existing case law bind English courts? Does future case law? So I think it is, one needs to I'm afraid the devil is in the detail, and it is extremely complicated, especially in some areas more than others. Immigration obviously is one of them.
Well, nothing may be simple. Perhaps Professor Tridimus is right, but I hope it's a bit clearer and more interesting after 2 hours, thanks to our hard-working panel. So can we please thank them, and thank you.
Thank you.